Well, good evening, and thank you for logging on again. This is the sixth CBFA support session of the 2019-20 season. Session this month is going to look at appeal procedures. So that will cover effectively FA misconduct appeals and league appeals, which will be submitted through to the county FA. I'm not going to lie, it is a little bit of a drier topic. It's quite regulation and procedure heavy. However, it is something that is quite often seen as being shrouded in a little bit of mystery, quite a lot of legalese, and there's potential for lack of transparency. So I do want to do my best to explain it as clearly and concisely as I can. And kind of take you through what that process looks like and what is required on an appeal. So the session this evening will hopefully last about an hour. I'll try and keep it short if I can. But we will look at the regulations behind FA appeal procedures, the types of appeal that can be submitted, what the application process is, and the grounds for appeal that you can use when submitting an appeal to us. And then actually look at what happens at an appeal board hearing and how that differs from disciplinary hearings that we covered in a previous session a couple of months ago. So moving on to the regulations first and foremost. This is kind of what underpins everything and what kind of enshrines that right of clubs, players, leagues and so forth to appeal against decisions taken against them. Before I get into the regulations themselves, I just want to cover a couple of the key terms that we're going to be using across the course of the presentation. Because they can tend to trip people up, or again, it adds to that kind of use of technical jargon and language, which can trip people up and cause confusion. So when you hear me refer to an appellant throughout the course of the session this evening, it is referring to the individual or the club who has submitted the appeal. Equally then, the respondent is the individual whose decision is being appealed against. So that would be a league management committee, the county FA, or county or national FA disciplinary panel. Once we get through to the end and what that appeal process has looked like, then the appeal will either be upheld or allowed, which basically means the panel has found in favour of the appellant and against the respondent. So they've agreed with the club or the individual who submitted the appeal. Alternatively, the appeal may be dismissed, in which case they are found in favour of the panel that made the original decision, and they have found against that individual or club who submitted the appeal. We use those terms a fair bit over the course of the presentation, so just wanted to make sure we're all on the same page with them. So, under FA regulations and in the FA handbook, all participants have the right of appeal where expressly provided for under FA regulations. Now, there's a new term in here again, and participants. You probably will have heard that phrase used if you've been on one of the previous sessions. Basically, participant is the catch-all phrase which is used by the FA to encompass anybody, single person or organisation who is involved in football. So a player is a participant, a referee, a club, a league, a county FA is a participant, as a member paid county and national FA staff, I'm considered a participant under FA regulations. So anybody who has a decision taken against them has the right to appeal where FA regulations allow. The bulk of those will come under decisions taken against them by a disciplinary commission, or it may be a decision taken by a league against them. Equally, you can appeal when it comes to debt recovery actions and where otherwise granted by the FA. So that is if there's something which isn't explicitly stated in the FA regulations, but an application may well be made to the FA requesting an appeal, and they may agree to grant it. That is, in the legalese language and technical jargon, at the discretion of the chief executive or an agent acting on their behalf. The vast majority of what we deal with, though, here in grassroots football, will be looking at decisions taken by disciplinary commissions, decisions taken by leagues, and in some occasions, decisions taken by the county FA. The disciplinary appeals are against the panel that's made that ruling, and a league appeal is heard, well, the appeal is submitted to and heard by county FA which sanctions that league. So although you may be a Berks and Berks club, if you are playing in the Oxford Male League, for example, want to appeal a decision that they've taken, that appeal would be submitted to and heard by the Oxfordshire FA. Equally, if you're in Hampshire playing in the Pete Houseman Youth League, you appeal to the Hampshire FA and so forth. If you're taking part in a league at step 5 or above, those appeals would go directly to the FA as their sanctioning body, although in some instances, particularly up in the Premier League and EFL, league competition rules will forbid an appeal in some instances. Now, the appeal itself can only be made by the personal body who is the subject to the original decision, the FA, or effectively international governing body. Now, this is key to us. The appeal can only be made by the personal body who is subject to the original decision. Now, what this means is it is the person or body who has had a ruling imposed upon them. If we look at it from a disciplinary point of view, that means that the player or the club who's been charged with misconduct and has had a decision taken against them, what it does not include is the victim. Because the victim in that instance, let's say of a serious misconduct incident, is not actually the subject of that original decision, because it's the perpetrator that's been charged and ruled against, the victim is not entitled to appeal that decision themselves. However, an appeal could be submitted on their behalf by the FA, and I'll come on to explain a bit more around that later on. The final category there of appeals by FIFA, WADA, or the National Anti-Doping Organisation, that relates really only to professional level and anti-doping offences, so it's not something that we need to worry about in grassroots football. Moving on around some of the regulations then, the decisions of an appeal board are final and binding and cannot be appealed again unless the regulations of that board explicitly state so. And this one is also quite important. It doesn't actually come under Rule H, it is elsewhere in the FA disciplinary regulations. But no new evidence can be submitted at an appeal. It is based solely on the original documents provided, unless an application is made to the appeal board and permission is granted to enter new evidence. Key to one of the things we're going to keep coming back to over the course of the presentation really is that appeals are looking at the decision that has been taken. They are not a rehearing of the original case. So you are charged in the first instance with an offence. You have a hearing where that offence is considered, and then a decision has been taken. At that stage, when you're submitting the appeal, you're submitting the grounds of that decision. You're not submitting the grounds of the initial incident. I'll come on to try and explain that in a bit more detail and a bit more clarity later on, but it is something which, again, causes some discomfort and some confusion, particularly on the misconduct cases when an appeal is submitted. People thinking they have an opportunity to represent themselves and retest evidence, re-question witnesses at an appeal board hearing, but that is not allowed under our regulations. So I've mentioned a couple of different types of appeal there, and I just want to kind of go into a bit more detail around the two largest types of appeal we have. First of those is going to be the FA Misconduct Appeal. Now, I did a presentation a couple of months ago through one of these WebEx sessions. It was available through our YouTube channel if you did want to go back and watch it, which looks at FA's disciplinary and misconduct procedures. Now, any proven decision as a result of a misconduct charge can now be appealed to the FA. So there was a restriction in place up until about 3 seasons ago, which was you could only appeal a decision which was 2 matches and £25 or higher. However, that's now been removed. So any proven decision, even if it just results in a warning to further to future conduct, can actually be appealed to the FA. Those appeals, as I said before, are submitted by the player or club who's been charged and was the subject of that decision. The FA, however, can appeal any decision taken by a disciplinary panel. So that includes whether the decision is proven or not proven. As I said, I will come into that in a bit more detail later on, but this is where should the victim of the alleged offence feel that they have been hard done by, or that the decision is so outrageous that it should not be allowed to stand, they can make an application to the FA to appeal on their behalf. Second type of appeal that we deal with, particularly at a county level, relates to league appeals. We're getting into that time of the season where we start seeing a few more of them across the county soon after New Year's. Seems that league points become a little bit more valuable, and as we progress through knockout cups and participation in those gets a bit more at stake and you're beginning to see silverware on the horizon, we do tend to see a few more appeals made against league decisions. So clubs can appeal any decision of a league management committee, again, where they are the subject of that decision. So that can be around fines that have been imposed against them. It can be around decisions relating to an accusation that they fielded an ineligible player, let's say, and therefore had points deducted from them, or they've been removed from a competition, and so forth. And then clubs can also appeal decisions taken at an annual or a special general meeting. However, those decisions can only be appealed on the grounds of unconstitutional conduct. Reason for that being that you're no longer appealing against the executive body of that league, but against a decision taken by the entire membership. Therefore, if you're looking at kind of that overwhelming endorsement of that decision as it comes from the entire league membership, it's seen that the only appropriate way of resolving that matter is if there has been a breach of constitutional conduct. So that may well be that the voting procedures have not been correct, or that the way that the general meeting itself has been conducted has not been acceptable. Let's say special general meeting, you can only consider matters that are on the agenda, and somebody were to introduce a new item onto a special general meeting agenda, which led to a club being kicked out of the league. That could be considered unconstitutional conduct and could be appealed. So those are the different types of appeals which can be submitted and considered. Now I'm going to just look through what that process of lodging an appeal looks like. The first part just looks at the two different approaches for misconduct and for leagues, but beyond that, the procedure and what happens once the appeal is submitted follows the same for both types. The misconduct appeals are submitted directly to the FA. That is because you're appealing a decision taken by a county FA body. Therefore, you have to submit an appeal upwards to our sanctioning body, who is the FA. You need to submit your intention to appeal to the FA within 7 days of the written notice of the decision, and then submit a full written appeal within 14 days. The reason for that break is it just gives us a little bit of time to get some of the gear, some of the machinery in order and start moving, so that we can start pulling together a response to the appeal and start making a movement on that. If participation is at stake and a player is under suspension, we really want to make sure that any appeal is heard as quickly as possible. The fees for misconduct appeals to the FA are on the screen. So it's £100 for those clubs at step 5 to 7, and for those clubs outside of the National League system, it is £50. League appeals follow a similar but different path. As I said before, they are submitted to the parent county of the league as that sanctioning authority, and the appeal needs to be submitted to the county within 14 days of the decision of the league. It is then also accompanied by a fee. In this case, for adult leagues, the appeal fee is £50, and for youth leagues, the appeal fee is £30. That may vary county to county, so if you're appealing to another county FA as a sanctioning body, some of those fees may be different, but within Berks and Berks it's 50 and 30. Now that appeal fee, in both cases, may be retained if the appeal is unsuccessful. and they find against the appellant. And it is also worth noting additional costs may be awarded against the unsuccessful party. So if it's deemed to be potentially a frivolous appeal that was not likely to be successful in any way, the appeal board may opt to impose costs. Equally, if the appeal board find in favour of the appellant, they can charge costs against the body who made that original decision. We have had that particularly in FA appeals, where county FA decision has been overturned and we've actually been charged costs as well. So it is something that does happen across the board and something that affects us as the county FA as well. You'll probably find in your league rules that it is required that you copy in the league management committee or the league secretary when you submit an appeal. We would ask the same if you're submitting the misconduct appeal to the FA, ask that you copy myself in or the discipline email address. That is a courtesy really, as I said before, it allows us to kind of start putting some of our procedures into place so that we can begin pulling together our response to the appeal and make that whole process as streamlined as possible. So the grounds of appeal. Now, those of you who may have been through this process before will have seen these terms come out, and this is where it gets slightly bogged down into definitions and jargon. So I'll try and explain each one carefully as we go through. Now, every appeal that is submitted does need to be based on one or more of these grounds. So if like to use the term, let's say a generic letter is sent in saying, I just want to appeal this decision, I don't believe it's correct, it's unfair, and so forth, you may find that the FA or the county FA will come back to you and just try to clarify which of these four categories it would fall under. So the first line of appeal is that the body whose decision you're appealing against failed to give the appellant a fair hearing. We try to make sure, particularly with our misconduct cases, that we do ask at the end of the hearing the person that has requested a personal hearing to receive a fair hearing. But there are cases where you may look at this as an avenue of appeal. Things that spring immediately to mind that might constitute an unfair hearing would be if there was a conflict of interest. Let's say it's a league appeal and the chairman of the appeal board is also the chairman of the club that you are competing with for the league title. In that kind of instance, you could say that actually there's a conflict of interest there, that the chairman of the appeal board is predisposed, more likely to find in against you, and therefore, let's say, remove points from you, giving his team more of an opportunity to win the league. You could say and argue there that you've failed to receive a fair hearing. Equally, if you haven't had the opportunity to represent yourself or your position adequately, let's say you've requested a personal hearing and that hasn't been provided to you, you might want to say that they haven't given you the opportunity to have a fair hearing. Second line of grounds of appeal would be that the body you're appealing against misinterpreted or failed to comply with the rules or regulations relevant to its decision. Again, examples of this might be that they failed to follow hearing procedures. Let's say that they haven't called relevant witnesses, or that they haven't given you the opportunity again to kind of put your case forward, or that they have missed specific deadlines that are required in order to have a hearing. So, for example, if you're required to provide 14 days notice of a meeting where the decision is going to be made about the case, you only provide 3 days notice. You might argue that actually that's an unfair hearing because you haven't had the opportunity to attend, but also that the body you're appealing against has gone against their own regulations, which say that it must be 14 days notice. Third grounds of appeal then is that the body that you're appealing against came to a decision to which no reasonable such body could have come. Now, this is probably the trickiest and hardest of the grounds of appeal to argue, and it's rare that it is successful. in order to win an appeal on the grounds that the decision is one which no reasonable body could have come to, the appellant effectively has to demonstrate that all the evidence was overwhelmingly in favour of the opposite outcome. Now, the definition that we use is that in order for something to have been an unreasonable decision, any other reasonable person of sound mind and fair judgment could not reasonably be expected to reach the same conclusion. Long-winded, I know, quite convoluted, but as I said, it basically has to suggest that all evidence is stacked to suggest it's a not guilty, that individual could not possibly have committed the act they're alleged to have committed, but it was found proven anyway. Marginal cases will not succeed. If it's almost like if you sat on my session looking around where we discussed wrongful dismissals and the referee has made an obvious error, that if there's a degree of interpretation and it's a question of force or severity of an offence, that is unlikely to be deemed as an unreasonable decision if there's any debate about it. Other thing to remember is that this is based around the evidence that is available to the Commission at the time, so you cannot enter new evidence that may support your argument here. So again, you're trying to argue that on the evidence the panel had at the first time of asking, that is an unreasonable decision. Final grounds is probably where we see the most successful appeals, as it is slightly more subjective, and that is around the body that you're appealing against has imposed a penalty, award, order, or sanction which is excessive. However, with that said, generally there are guidelines which these bodies are following when they issue these kind of sanctions and penalties. So if you look again at the misconduct process, the FA have a set of sanction guidelines which are applied in all cases. And so when a disciplinary panel is considering the penalties to impose on a proven case, they will refer to those sanction guidelines and base it on their interpretation of the level of severity of that offence within those guidelines. So an appeal against this must show that that penalty that they've imposed is excessive, even when you consider the sanction guidelines for that kind of offence. The league appeals, equally, the management committees and the subsequent appeal board will refer to that league's rules and fine tariffs, as well as wider precedent across the game. So regular a kind of appeal that will come up. We've had appeals submitted against us on these grounds and submitted to us, which may be that a team has fielded an ineligible player and the county FA in a county cup game has removed that team from the competition. Now that is general action that's taken by the majority of leagues and competitions across the country in those kinds of situations up to the professional game. So again, if an appeal board is looking at that and trying to decide whether that sanction is excessive, if it is in line with quote unquote industry standards, again, you're struggling perhaps to show that that is an excessive or an unfair punishment for that kind of offence. So let's say that decision has been taken against you, you wish to appeal, you kind of know what those grounds of appeal are, and you want to proceed to the point where you're submitting a notice of appeal. Notice of appeal is the technical term we use for kind of starting the ball rolling and the submission from the appellant. So what we're looking for if an appeal is coming into us would be that the appellant identifies the specific decision which is being appealed. Always helps us know exactly what it is, particularly on league breaches or misconduct cases. Set out the grounds of appeal, so highlighting which one or more of those 4 grounds we just discussed their appeal falls under, and also as part of this demonstrate why it would be substantially unfair not to alter that original decision. They should also set out a statement of fact upon which the appeal is based. That the language used in the FA regulations, but basically what this point is where you get to make your case in writing as to explain why that decision is unfair, why it shouldn't be allowed to stand, and why that ground of appeal should be upheld. If you are appealing a disciplinary sanction, at the point you submit an appeal, you can request that those sanctions are set aside. Now, if you don't include it at this stage of an appeal submitted to the FA, those sanctions will not get set aside and you will still have to comply with them. This decision on whether to set sanctions aside is solely at the discretion of the FA. What they'll look at when trying to make that decision is probably around the severity of the case and some of the facts surrounding the case and the grounds of the appeal. Let's say that someone's appealing a referee assault charge, which has led to a 10-year suspension, and are appealing that on the grounds that the penalty is excessive or that they believe it's an unreasonable decision. Given the severity of the incident and the accusation as an assault charge, it's unlikely that that would get set aside because the FA obviously still has a duty of care to the participants. And if it's already been tested effectively at two levels, at the charging decision by the county and at the county FA disciplinary panel, then it's unlikely that they will remove those sanctions until the point that the appeal is heard. If, however, it's a slightly lesser offence, say abusive language towards a match official, that's led to a 2 or 3 game suspension, the FA may well choose to set that aside whilst the appeal process is underway. As a county FA, we've got a bit more discretion when it comes to the payments, because we are allowed, we have a default payment term of 14 days, but we can extend that at our own discretion. So generally, if an appeal is submitted, we will extend the payment deadline on that fine until that appeal has been heard. However, we don't have that kind of discretion over suspensions. As I said, if it's not requested and granted to be set aside at the time the appeal is lodged, unfortunately, you will still have to miss those games regardless of whether the appeal ends up being successful or not. At the notice of appeal stage, you'd also have to include the accompanying appeal fee, depending on what that is. As mentioned earlier, if it's a disciplinary appeal to the FA, it's either £50 or £100, depending on the seniority of the club. If it's a league appeal, it's £30 or £50, depending if it's youth or adult. And finally, at the notice of appeal, you should apply for new evidence to be submitted if applicable. And I'll come on to that now. So the application for new evidence. As I mentioned before, an appeal board hearing is not a rehearing of the original case. So therefore, you're arguing that the panel made that decision in the first instance based on the evidence they had available to them at the time, has reached an unfair or a wrong decision. So therefore, any new evidence will only be granted in exceptional circumstances. And that has to, the application for that has to either come from the appellant at the time they submit the appeal or from the respondent at the time that they reply to the appeal. The application must set out the nature and the relevance of the new evidence. In broad terms, you're not able to reply to all parties and immediately include the new evidence in there. It's taken as a separate action. So you describe what the evidence is, why you feel it is relevant, and why it should be accepted by the panel, and also must explain and justify why it was not previously presented to the original hearing. To try and give you an example of this, I'm trying to use the most generic terms that won't get me in trouble. County FA had a decision appealed last season, made a decision. Following that, it was appealed and obviously to the sanctioning body and progressed. However, after the point of our decision in the first instance to the point the appeal was lodged, on social media, the appellant had effectively admitted to the offence, but was still appealing it, saying it was an unreasonable decision. We therefore made an application that we wished to enter new evidence. We explained that the nature of it was we felt that it shows an acceptance or admittance to the offence and to the punishment, Obviously, it could not be included in the previous hearing as it had only come to light after that initial decision had been taken. We did feel it was fundamentally relevant to our defence to the appeal. In that case, it was granted and hopefully supported us. But those are the kinds of times when you may see an application for new evidence will be granted. Equally, if new evidence only comes to light as the disciplinary or the league process is going underway, and therefore could not have been presented, but would fundamentally change the terms of the case, you may be allowed to re-enter to that or enter new evidence at that stage. So once appeal has been submitted, it is then kind of passed over to the county FA to progress and to move forward. The county FA or the FA will work with the appellant and to clarify and confirm the grounds of appeal. What we're not doing here is trying to support the appellant it's not an endorsement or an effort to bolster or improve their appeal. What we're looking here is that we can understand that it's unlikely clubs will have gone through this process or this experience before. And as I've mentioned several times, the regulations are quite complex, full of technical jargon and legalese and FA language. So from a county FA point of view, we will not guide a club if they're appealing a league decision, let's say, but we will work with them to ensure that all the documentation they need to provide has been provided, and that we can, between ourselves and the club, identify one or more of those four grounds for the appeal to be listed. Comes back, I guess, to that responsibility we have to all members, whether that is the league whose decision is being appealed against, or the club who's making that appeal, got a responsibility to work with all parties and support them in the interest of transparency and fairness, and just trying to make sure that the correct decision is made ultimately. Equally, we will work with clubs and players who wish to appeal decisions that we've taken through the disciplinary process. We'll offer them procedural advice and clarification on regulations to support them in appealing our decisions to the FA. Ultimately, it's we're governing in a regulatory body. We're not, I always say, I'm happy for people to appeal our decisions, because ultimately, even if the appeal is dismissed, it shows that we are still operating in a fair and transparent and correct manner. So, as I said, we'll work with the appellant to clarify or confirm exactly what the grounds of their appeal are. We then contact the respondent to the league, or the FA will contact us as the responding county and request a written response to that appeal. Now, under regulations, the respondent has 21 days from the date the appeal is lodged to provide their response. What we will quite often try to do is encourage them to respond sooner. It's always with a caveat: if they want to take the full 21 days, that is within their rights. However, quite often, if participation is at stake, particularly in a cup competition, let's say, where actually it's taken the league or the competition 2 weeks from the date of the game to raise the charges and consider the case, taking the appellant 2 weeks to submit an appeal to us, 4 weeks already, and then it takes the league 3 weeks to reply to our request for a response. We're already looking at 7 weeks since the date of the game that we're even beginning to get to the point where we're trying to schedule a hearing. And you may therefore be looking at 8, 10, 12 weeks from the date of the incident until a final decision has been made on it, and the game is either replayed or we're able to proceed with the next round of the cup. Therefore, we try and work with all parties and as much as possible encourage them to respond as quickly as possible. As I said before, that's where copying the league or the county in the initial appeal will help, because they can start the ball rolling and getting the response to the appeal before they even hear from the county or the FA who were coordinating that appeal. And then we work with both parties to confirm the appeal dates. For those of you who are part of leagues, and you may well have received these kinds of emails from me, generally what we tend to do is I will, as soon as the appeal comes in and we've confirmed everything, it will get packaged up with a cover sheet, it will get sent out to the league secretary. we explain what information we want, copy of the decision and the charge, copy of the A correspondence, written response within 21 days. Appreciate if we can get these sooner so that we can progress. And we will at that stage say, please can you also let us know any dates you would not be able to attend an appeal 4 to 6 weeks later. Again, it just helps us with keeping everything ticking over as quickly as possible. So the response to the appeal, and this is what is then required from the county FA if it's a misconduct charge, or from the league if it's a league appeal. Copies of all paperwork relating to the original charge and decision. So probably aware that any time the county sends out a misconduct charge, you'll receive a formal charge notification explaining what the offence is you're alleged to have committed, give you the opportunity to accept or deny the charge and respond. Once that response has come in, we have the disciplinary panel, whether by correspondence or in person. Decision is made, and the club is notified of the outcome of that panel, of that decision. Sorry. The league process should be following a very similar structure, in that league should be issuing a charge to a club for a rule breach, giving that club the opportunity to respond, accepting or denying the charge, and giving them the opportunity to either have the case dealt with by paper or in person. Once the decision is made, again, notification goes out to the club confirming the decision, and it is at that point that the 14-day appeal window opens. So once we contact the league and request the response to the appeal, we would expect copies of all of that kind of paperwork so that we have that in front of us and we're able to see exactly what it is that the appealing club has been charged with. Then we would look for a written response detailing how and why the original decision was reached. If that includes committee minutes, even better, but we would hope to see some kind of explanation as to why that decision was reached and why that penalty was imposed. And then the respondent, the league or the county, as I said before, also has the opportunity to apply for new evidence to be submitted if applicable. Once we've gone through all of that paperwork, which, as I said before, can take anywhere from 3 to 7, 8 weeks from the date of the actual incident, we end up at the appeal board. We pull everybody together and try and make a final decision on it. So an appeal board, very similar to a disciplinary panel. It is a 3-person panel with a secretary. Traditionally, these have been held in person, but you do now have the opportunity to request the appeal be dealt with by correspondence. And if you do ask for it in person, then we say that a maximum of 2 representatives should attend from each side. So 2 from the the appellant, and 2 from the respondents. If you submit an appeal to the county for a league decision, those hearings will generally be held at county FA offices in Abingdon. You'll probably have me as the secretary, and some of our senior disciplinary panel members will be sat as the appeal board. If you're appealing one of our decisions relating to a disciplinary decision and request that the appeal be dealt with in person, then we all trundle off on the train down to Wembley Stadium, and we will sit in one of the corporate boxes there with a lovely view over the pitch as we sit in front of an FA appeal board. Victims and the match officials, however, or in the case of a league appeal, the other club that may have been involved in the game, are not invited to attend the appeal and are not invited to provide written submissions. Again, this is where we come to the fact that it's not a rehearing of the case. The challenge is now against the individuals or the board that made that original decision. So to all intents and purposes, at the appeal board stage, the witness testimony of the referee is no longer relevant and can no longer be tested in person. And ahead of an appeal board hearing, you will receive copies of the appeal bundle generally about 3 days in advance of the hearing. That just pulls all of the paperwork together so that all parties have the opportunity to see everything that has gone to the appeal board for consideration and will be discussed. Now, the format of an appeal is markedly different to a disciplinary hearing. So this is, again, where it tends to trip a few people up. The key thing here is that the appellant has the first and the last chance to speak. So the way it actually then works is that the appellant presents their case first of all, makes an opening submission around why they feel that the decision of the original body is unfair, unjust, or excessive. And it gets to set their stall out and present their case to the panel. The respondent, so the legal county, then presents their case, and same thing, they will provide an explanation as to why they do feel that their decision was justified and was correct, and they may respond to a couple of the points that the appellant has raised in their opening submission. Once that's happened, the respondent has the opportunity to sum up, and then it's thrown back to the appellant to have a final sum up and effectively respond to the comments made by the original body that made that decision. So as I said, the appellant has the first and the last chance to speak. Now, throughout the hearing, the panel can ask questions of either party at any time. However, generally the appellant and the respondent are not allowed to cross-examine each other. So it is all, although it is in the presence of each other, the dialogue and the presentation is between the appeal board and, first of all, the appellant, and then the respondent, and then back to the appellant. Once we've gone through those 4 stages and gone through that process, the panel will retire and make their decision. Once that's been reached, both parties will call back into the room and the appeal board will announce their decision. Certainly at the county level, we make a big effort to try and provide detailed reasons as to how an appeal board reaches their decision. It used to be more standard practice at the FA, but recently some of the appeal reasons have become briefer and just provide the outcome, but with no explanation. However, we felt that within Berks and Bucks, being able to provide some of that context around why the appeal board's made the decision that they have, not only helps the league learn from any issues which may have meant that the appeal board has found against them, but also allows us to make sure there's consistency between different appeal boards, as we have a central repository here in the county where we can view those decisions, and we can make sure that an appeal board one season with 3 panel members will be in line with a decision taken 6 months, 12 months down the line, potentially with different panel members. Either way, those written decisions will get sent to both parties. Generally, if it's a county FA hearing, generally they'll be sent within about 20 minutes of the appeal board being over. So unless you live in Abingdon, they will probably be with you by the time that you return back to Milton Keynes, Slough, Reading, wherever you may be travelling from. As I said, we just feel that that is a more transparent and a more supportive procedure. Talks about the appeal board will make a decision. I just want to go into exactly what those decisions are that are available to the appeal boards. So as I mentioned at the very beginning, the appeal board has the power to allow or dismiss the appeal. So it can be upheld or it can be dismissed, and that is in full or in a part. It can happen that it is cut and dry, that the decision is completely overturned or is completely upheld without any kind of amendment, in which case we would say that it has been, the appeal has been upheld or has been dismissed in full. In that case, the original sanctions would remain or would be overturned and expunged in their entirety. And in the case of a disciplinary decision, let's say, if a decision is overturned on appeal, it will be removed from that player's permanent record. So there'll be no remaining record of it having existed effectively. The appeal board, however, does have the opportunity to adjust the decision of the original body. So they can uphold the appeal, but in part. So let's say that they decide that the penalty of the appeal board was excessive, the decision and the penalty awarded by a disciplinary panel in the first instance was excessive. Rather than remove it entirely and say that the entire case is dismissed and that although that individual has clearly committed an offence, they should not serve any punishment, they can amend and adjust that penalty so that it is lower. And again, we've had experience of this at the county FA level, where particularly amongst our higher level offences, which may see suspensions of upwards of 3 or 5 years, they can be reduced on appeal to 1, 2 or 3 years, let's say. The formal wording that the FA used for this is that the board has the power, the board can, quote, exercise any power which the body against whose decision the appeal was made could have exercised, whether the effect is to increase or decrease any penalty, award or sanction originally imposed. So it's very explicit there, they can increase it, they can decrease it, or if there is another decision that that body could have made, they can agree to impose those. The appeal board can also order that the matter is reheard in its entirety. As I mentioned several times now, appeal is not a rehearing of a case. However, if they feel that there has been some kind of miscarriage of justice or failure of procedure, but there could still be a case to answer, and all evidence should be tested properly in the correct process, then the appeal board can order that the case is reheard. So those kind of look at the different ways that the appeal board can make a decision around the fundamental facts of the case. In addition to that, they have the opportunity to order that the appeal fee is forfeited if the appellant is not successful. And as mentioned before, they can impose costs on either party as they deem appropriate. And this is again something that will sometimes happen here at the county, where if one party does not attend an appeal, or we feel that they have made a serious error in their original decision, we may order that they reimburse the appellant the cost of their expenses. Generally, we won't, however, impose any costs relating to the county FA and the costs we've incurred in going through this process. Finally, the appeal board can make such further or other orders as it considers appropriate. Again, nice and vague. I love it when they are nice and vague like this. However, what we're looking at here really is that an appeal board could, let's say, argue that an individual is required to attend an education session, perhaps, or that required that a league issue a memorandum or a communication to all clubs within their league clarifying rules that may have been breached or may not have been appropriately explained before. So again, it just gives a little bit of scope to hopefully allow the common sense to come in, and if there is a massive oversight which has happened, then or something that can be rectified outside of existing rules or the existing decision or financial basis, gives the appeal board the opportunity to impose those. So that kind of looks at the appeals process, start to finish. I've mentioned a couple of times that the FA have an opportunity to appeal decisions, and I'm just going to briefly touch on what that looks like and when it may happen. So the FA have their own regulations around the grounds of appeal that they can submit, and they have 3 grounds rather than the 4. 3 grounds that they can submit an appeal are that the body who made the original decision misinterpreted or failed to comply with the rules or regulations relevant to its decision. Seen that one before. Again, came to a decision which no reasonable such body could have come, as before. But then finally, they have the opportunity to appeal a decision if they believe the original body has imposed a penalty, award, or sanction which is so unduly lenient as to be unreasonable. Now, in the same way that a participant, a player or club that has been charged with misconduct and feels that they may have been fined excessively or issued an excessive suspension, can appeal on that basis. If the FA feel that actually a county FA disciplinary panel has imposed an incredibly lax penalty, they have the opportunity to appeal that and argue with their own with an appeal board that actually the penalty should be increased because of the severity of the alleged offence. As I said before, this is also where the second line here, it's an unreasonable decision, is where the FA may look to appeal a decision on behalf of the victim if a case is not proven. So the process for an FA appeal is as follows. First of all, the FA will contact the county and request the case papers in the first instance. So we'll provide those to them, and they are then reviewed by the FA's regulatory legal department. It's processed by Reg Legal. This takes it out of the hands of judicial services, which are the body that forms the appeal board. And it effectively, as I said, is sent to some of the solicitors and barristers and legal minds, legal wigs up at the FA to consider whether an appeal is appropriate. The FA will then make a decision whether or not to appeal the decision and notify all parties, including the participant charged, because obviously if a participant has gone to a disciplinary hearing and been found not proven, it comes as a bit of a shock to them if a month or 2 months later they suddenly find that out of nowhere they have it's been overturned. So they are informed at that stage that the FA will be appealing their decision. County FA then provides observations as a respondent, same as we would do in a normal case. And the appeal is then heard by a separate FA panel and will always be heard by correspondence in those cases. Once it's been considered, the FA notifies all parties on the outcome of the appeal. Now, I appreciate there may be a bit of a perception that if the FA is appealing the decision of a county, it's almost guaranteed that that decision or that appeal will be upheld. However, as I said, they are generally two separate processes and handled by two separate departments and people with two groups of different expertise and different perceptions. So the appeal decision is taken by Reg Legal, but it will still be adjudicated on by a trained FA appeals board who will look at all aspects and obviously look at the response from the county as to how they made that decision they did, whether it is a low suspension or whether it is a not proven decision on a misconduct case. Once again, participant charged and the witness and witnesses and the victim are not invited to make submissions, however. So they won't either come to a hearing and they won't provide written correspondence as part of that appeal process. Right, time for the practical advice. And those of you who have sat on these before know that I try to always include this key messages to take away really around in the real world, in practical terms, what can you do if you are in this kind of situation where you may want to appeal a decision. First piece of advice is very much to watch the timeframes involved here, particularly for the misconduct appeals. Appeals submitted outside of that time frame of the 7-day intention to appeal, 14 days for the full appeal, will not be considered by the FA. So you do need to be quite hot off the mark with those. You should always get informed after a personal hearing what the appeal procedure is, and it is at the bottom of every disciplinary results letter. If not, I'm going to jump down to the fourth line here. If you want to appeal but you don't know what to do, please do contact the county FA. We're always happy to provide advice on the procedures. However, what we can't do, obviously, is offer advice on whether or not to appeal, particularly because there's a financial implication here. What grounds to appeal on, because that has to come from yourselves as the appellants, and the potential chances of success. We will simply advise on the process and the potential outcomes in terms of the decision may be upheld, overturned, and you may incur costs and so forth. I have no issue with people appealing our decisions. I believe it's the right thing to be able to do. As I said before, it helps us demonstrate that we are acting in a transparent and fair manner. And hopefully, yes, I do. If an appeal is submitted, I do want to make sure as much as possible that the appeal or the original decision is seen to be fair, because it indicates our procedures and decisions taken by our panel to make sure means we know that we are doing the correct thing. However, if we aren't doing the correct thing, then we need to know that, and if that's through an FA appeal, then it's a learning experience and education for us that we will obviously adapt and learn from. Particularly when you look at those 4 grounds of appeal, if ever we do lose an appeal on the grounds of failing to follow rules and regulations or failing to provide a fair hearing, that is something which we would need to seriously look at our own internal procedures and improve those upon. So if you do feel that it's appropriate to appeal, we will support you in advising what that process is, and then we will, as I say, it is certainly not held against anybody who's appealed against us. Next piece of advice, remember to request the sanction be set aside if it's a disciplinary case and if it's applicable. If it isn't done at that stage, then it cannot be set aside. Also advise to look at the FA sanction guidelines and the league rules, particularly if you are looking to appeal on a regulatory basis or on an excessive sanction. As I mentioned before, there are recommended and mandatory sanctions for disciplinary charges, and league rules will state potential fines and outcomes for rule breaches. Just recommend reviewing these, because if you're appealing on the grounds that something is an excessive sanction, if it is part of a guideline that that is an appropriate sanction, it is a much harder challenge to say that this is excessive if it falls within the remit of that decision-making body. Say, for example, that a panel has imposed the mandatory minimum sanction for a serious offence on a match official. So let's say an 84-day suspension for physical contact on a match official. You really can appeal that on the basis that you think it's excessive. However, it is highly, highly unlikely it would be successful. And to be honest, if in those cases you may run the risk of actually an appeal board increasing the sanction if they find against you. Final piece of advice then is to remember, as I said throughout this evening, that an appeal board hearing is not a rehearing of the original case. It's not a chance to cross-examine witnesses, to test evidence, to try and bring new arguments in or to try and bring new evidence in. It is a review of the decision-making process and the outcome of the decision made by that initial body. And again, if you have any clarification or advice on that, please do come to us. Well, that pretty much wraps up the appeal process and our advice on appeals. At this stage, I just want to remind everybody that our previous sessions are available on YouTube. Turning into YouTube sensation, which I never thought I would be. You can access that through our website. If you go to the main dashboard, so the main homepage, clubs and leagues, club management and BBFA support, you will see links to all of the previous sessions. This is the 6th one now, so we've covered pretty much all of the rules and regs you could hope to at this stage, as well as a little bit around recruitment and management of volunteers and complaints. After this, the next session will be held on the 13th of February, Valentine's Day or pre-Valentine's Day special, 7 p.m, once again online, using the same link as before. And we'll look at player recruitment and transfers, and we'll delve in a bit more again into correct procedure for approaching players. We'll look at the practical system on the whole game system around player registrations for adding players, but we will also look at proactive avenues and approaches you can take for recruiting players from outside your existing pool and from the wider community. So I hope you'll join me then. If anybody has any questions, please feel free to pop them in the chat. I'm happy to stick around for a few moments and try and pick up anything that, any questions you may have. I hope you found this evening useful, and I wish you enjoy the rest of your evening. Thank you very much.